Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Well, several days ago on September 6th, Donna Adelson's lawyers asked the court not to admit certain evidence at trial. This is a motion in limine, and it's designed to limit the amount of evidence or the type of evidence that is contained in the motion. So the first thing that was on the agenda was the testimony of one of the police detectives, Sergeant Christopher Corbett, about a summary of evidence. And the issue was whether that summary was substantive evidence such that it could go back to the jury, or whether the summary contained argument such that it could not go back to the jury room during deliberations. The state wants the detective to testify about him using the call records and emails and text messages to put together this summary of communications between Donna and Charlie and Wendy, Harvey, Katie, and the two shooters. And there's no question that the detective can do that. Each one of those calls is evidence. Each one of the records of those calls is evidence. The contents of the calls, if they were recorded, is evidence. The emails are evidence. The text messages are evidence. All of those things are evidence. And there's no question that the detective can lay the foundation necessary to admit all of those documents into evidence. So you might be wondering, well, if that's the case, then why are they complaining about this summary? We'll get to that. The summary is a 395-page report, and that report supposedly summarizes the evidence in the individual documents. It doesn't really fit the rule, and we'll talk about that here in a second, but the evidence in the individual documents, as I said, for example, the emails, those always can go back to the jury. But the summary, the defense says, no, that can't go back to the jury.
There's no dispute that they can use the report as a demonstrative. There's no dispute that for the admissible items, they can put in the admissible items. So I'll give you an example. Email between Wendy Adelson and Donna Adelson. Clearly it's admissible, provided it's relevant. The ones they provided are relevant. Clearly admissible. The underlying email can be admitted, shown to the jury through an appropriate witness, if they call Wendy Adelson, for instance. Okay, so that email is admissible. But the summary of the email in the exhibit, the summary of the 1 or 2 page email in this exhibit can be shown to the jury, but it doesn't qualify as expert testimony or a proper summary exhibit to be admitted. Does that make sense what I'm saying? Ultimately, that 329 pages right now doesn't go back to the jury. It's a closing argument, essentially. When you look at his 329-page exhibit, and again, I'm getting a little ahead of myself, but when you look at his 329-page exhibit, it's essentially Ms. Kappelman's closing argument.
Under Florida law, there is a provision for a summary of voluminous records. Several years ago, I had a nursing home case where a patient was cared for over a period of 76 days, and our issue was that she didn't get nursing care for a large portion of that. Well, when you go through a medical record, each day is not written down on one page. The things that happen on each day are written on a number of individual sheets. The aides make notes. The nurses make notes, the physicians make notes, dietary workers make notes. And so if you cobble all of that together, in order to find out everything that happened on a particular day, you'd have to look at about 9 or 10 different records for that day. And when you're dealing with a stream of about 76 days, well, then you've got a real problem because you'd be flipping back and forth between the medical record so many times that you'd probably tear the pages out of a notebook. So I did a summary with a 90-day calendar. And like I said, our characterization was that there were only 26 times that a nurse actually made a chart entry on the patient. And so The rule is, generally speaking, that if you didn't write it down, you didn't do anything. And so they can come in and say, well, yeah, we saw her every day, but if they can't prove it, that's a problem. So I did this summary with a 90-day calendar, and I showed all the times the dietary people were there, and they were there every day. And I showed all the times the aides were there, and they weren't there. They didn't make notes every day. They made them infrequently and sporadically. And the nurses only made 26 entries over that 76-day period of time. And there were very, very few as the woman became closer and closer to death. Now, that summary was admitted as a summary of voluminous records because the records were voluminous, and it was necessary to distill them down into something so that in the jury room they wouldn't be flip-flopping back and forth through the medical record. Well, Missouri's rule is a lot like Florida's rule, and here's what Florida's rule says. When it is not convenient to examine in court the contents of voluminous writings, recordings, or photographs, a party may present them in a form of a chart, summary, or calculation by calling a qualified witness. The party intending to use such a summary must give timely written notice of his or her intention to use the summary, proof of what shall be filed with the court, and shall make the summary and the originals or duplicates of the data from which the summary is compiled available for examination or copying or both by other parties at a reasonable time and place. A judge may order that they be produced in court. If you think about it, there is a problem with that, and you can probably see what that problem is. Let's suppose that in this case, and I'm sure this isn't the case, but suppose there's an email between Charlie and Big Mama, and Charlie says to Big Mama that Katie and I are coming over to talk to you about that special dish we want us to help you prepare. In looking at that, you can plainly see that they're talking in code because they're not actually mentioning any particular food. So a jury could reach its own conclusions about what that means, and that's why it's admissible, because it could be directly relevant on the issue of motive. If the summary says, for example, 11/11/2011, email from Charlie to Donna coming over to discuss plans to commit the acts under investigation, that's not a summary because it interprets the meaning of the words used. It doesn't just quote the relevant part of the email. When you introduce characterization into the mix, you are no longer summarizing, you are editorializing. So the state's argument was that the summary was appropriate and should be sent back to the jury.
Second, but as far as the summary goes, he's not testifying as an expert to everything in the summary, but he's testifying as an expert to a large part of the summary when it comes to cell site location data and how far, who's using a handset at the time, and how far the person is from the cell site location.
The judge was very active during the argument, asking excellent questions and sort of teasing out the meat of the various arguments. It's obvious to me, listening to the judge, that he knows the law cold and he knows exactly what the rules are and how they apply. At the close of the argument, he ruled.
I'm prepared to rule on part of it today as to whether or not Sergeant Corbett can be properly qualified as an expert witness. I will find if Sergeant Corbett is capable of testifying to the interpretation of the records that go beyond just merely where the towers are, what was pinging, and what the phone records show. That would go to scientific or technical expertise in which he is properly able to give an opinion. As to the summary itself, and I do not want to belabor this point, but I do believe I am going to need to hear from Sergeant Corbett specifically as to how he put this together, and his opinion was informed by the information that is in the summary before I can rule on it. Otherwise, I agree with the defense position. This is proper as a demonstrative, but to admit it as evidence, I'm going to need to hear more. We'll have part two then, in which Sergeant Corbett can testify concerning how the summary was created and how his opinions were formed by the evidence that are within the summary after we have the docket sounding next week.
In addition to dealing with the detective, the defense team sought to exclude testimony about Wendy Adelson changing the children's name from Markel to Adelson, and about the book that she wrote. The rationale, of course, is that the evidence is irrelevant. Wendy is not on trial and has not been indicted or named as a co-conspirator. The rule on relevance, and we've talked about this on this channel here numerous times, is this: relevant evidence is evidence tending to prove or disprove a material fact. And what is a material fact? Well, a materiality means the significance or importance of a piece of evidence or information in relation to the particular legal matter. To be material means to have probative weight, in other words, the weight necessary to prove a fact, and that it's reasonably likely to influence the tribunal in making a determination that is required to be made. The question then becomes, how can what Wendy did in changing her children's names, which is certainly disrespectful to her deceased husband and to his extended family, what does that have to do with Donna's charges? On its face, it would not appear to have any relevance at all on whether Donna commissioned or paid for people who did the killing. Thus, the chief use by the prosecution would be to attack her character, what lawyers call bad person evidence. Florida law prohibits this. Florida Statute 90-6.609, a party may attack or support the credibility of a witness, including an accused, by evidence in the form of reputation, except that 1. The evidence may refer only to the character related to truthfulness. We don't know what Adelson's lawyers said about this in their pleadings, but it must have been pretty persuasive because they didn't argue it, and here was what Judge Everett ruled.
As to another matter in which I am prepared to rule on at this point, concerning the defendant's motion in limine, concerning testimony from Wendy Adelson as to the storyline of her book and also changing the names of the children, I will permit the state to use this information for impeachment, depending on what is developed during the examination of Ms. Adelson.
Now, why might the state want to impeach Wendy with this information about changing her children's names? If she has testified differently than she testifies at trial this time about that issue, then they can get into that. And that's the whole purpose of impeachment. You impeach with a reputation for not having told the truth previously, or for not telling the truth this time because you testified about something else earlier. So that might be why some of those things might come up, but it's only if she testifies differently than she has testified previously. As I said before, Judge Everett is pretty impressive as a trial judge. It will be interesting to follow this case once it actually gets into trial. So that's what I have for you today. Thank you very much for watching. If you have the opportunity today, go out of your way, do something nice for someone, make somebody's day. Anytime we do a kindness and they pass it on, it just makes the world a better place. And that's a good thing. After you've done a kindness, come on back down here to the beach, join me down here, and we'll talk about something else great tomorrow. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.